Thank you. So I think probably almost everyone in the room has heard about the Irish referendum on abortion that occurred earlier this year. Basically, for anyone who doesn't know, in a nutshell, in May, in what was a momentous result for women's reproductive rights, the Irish electorate voted overwhelmingly to remove the country's notorious constitutional ban on abortion. And in doing so, they voted essentially to legalise the provision of abortion care in Ireland, to enable Irish lawmakers to enact laws allowing women in Ireland to access reproductive health care in their home country for the very first time. And so the referendum result really marked a significant moment for social justice, for equality, and for women's health in Ireland. And it enabled the repeal of what had been one of the world's most restrictive and most harmful abortion laws. This constitutional ban on abortion, also commonly referred to in Ireland as the Eighth Amendment, was a law that had prohibited abortion in every situation except where a woman's life was at substantial risk. And as a result, the law had created a range of situations. It had created a situation in which every year thousands of women had to travel out of Ireland to foreign countries to access safe and legal abortion care. It had created a situation in which, in the most tragic of circumstances and cases, some women who were unable to travel and who were denied care at home died as a result. And basically, it had created a situation in which Ireland's laws on abortion remained wholly out of step with those in place in most other European countries. Now, the referendum result marked the culmination of decades of effort by multiple generations of actors in Ireland. And as is common in work to achieve this kind of social change, it was brought about because of contributions over many years of a very wide variety of stakeholders. Women who broke the silence and the stigma and spoke about having to travel for abortion care, medical professionals, campaigners, activists, ordinary individuals and families who joined demonstrations, civil society organisations, trade unions, student unions. So many sectors of society played a very significant role in bringing about this law reform process. But what about lawyers and the law? Did we have a role in recent years in supporting and enabling this social change? Were there ways in which, over the past 4 to 5 years, the use of law and legal mechanisms catalysed accountability, galvanised political will, and influenced public opinion? Well, the short answer is yes. But I think what's the most interesting about it is the mechanics of it. What were the ways in which we actually used the law and legal mechanisms to support change? And notably, I think, the legal strategies we used and that proved effective in the last 5 years did not involve challenges before the Irish courts or before the European Court of Human Rights. And these would have been the mechanisms and the frameworks that Irish and European lawyers would usually have turned to. However, in the case of Ireland's abortion ban, these avenues had not proved effective. And the European Court of Human Rights had been unwilling to hold that Irish prohibition on abortion was a violation of the European Convention. And national courts had made it clear that there was no room for interpretation in the application of the ban. They had articulated that the only exception to the prohibition on abortion was when a woman's life, as distinct from her health, was at risk. And as a result, as lawyers, we had to think creatively and outside of the normal legal playbook. How could we achieve legal condemnation of this restrictive abortion law? How could we showcase in legal terms the harm it was causing to women? And how could we generate sufficient political will so as to expedite meaningful constitutional and legislative change? Well, in the end, we turned not to national or European mechanisms, but to international law, and specifically to the International Covenant on Civil and Political Rights, a multilateral human rights treaty ratified by Ireland, and to its supervisory body, the Human Rights Committee, which has the jurisdiction to adjudicate complaints of violations from individuals against a state party. And in 2013 and 2014, we filed 2 cases with the Human Rights Committee on behalf of 2 Irish women, Amanda Mellett and Siobhan Whelan. Both of these women had received fatal fetal diagnoses from their doctors in the course of their pregnancies. They were told by their doctors in Ireland that as a result of fatal conditions, their pregnancies would not survive until term or their babies would die very shortly after birth. And both women were grief-stricken and decided that in these circumstances they could not continue the pregnancies. However, as a result of the Irish ban on abortion, the only option available to them, if they remained in Ireland, would have been to carry the pregnancies to term. and because they decided to end their pregnancies, the continuum of healthcare was severed for them in Ireland, and they had to make their own arrangements and travel to another country at their own expense in order to access legal healthcare. Now, when we filed these cases, there was a good deal of scepticism among some in the legal community, and I think in general this was generated in large part by three interrelated factors. So firstly, the committee and its mandate to adjudicate cases was not well known in Ireland. There had previously been only one decision against Ireland by this committee almost 20 years earlier on an entirely different subject matter. And so there was very little familiarity with the mechanism. And secondly, the committee is not a court, right? It's a quasi-judicial body, and there are varying opinions among international experts as to the binding nature of its decisions. And even if you do believe that under international law, the Irish state would have a good faith obligation to take steps to comply with the committee decisions, they are different in nature from, for example, the judgments of the European Court of Human Rights. And thirdly, and related to this, the Covenant on Civil and Political Rights is not incorporated into Irish law, and so there is no enforcement mechanism through the Irish courts. And as a result, there were question marks as to whether the challenges on behalf of Amanda Mellett and Siobhan Whelan would have the necessary impact in Ireland. Would they spark the public imagination and attract sufficient attention? If we received successful decisions from the committee, would they ignite a significant and sufficient level of accountability and political will so as to galvanise reform? Well, in 2016, the committee issued its decision in Mellett in Ireland, and it held that Amanda Mellett had been subjected to cruel and inhuman treatment by virtue of the Irish legal prohibition on abortion, and because she had to travel to a foreign country away from doctors and nurses that she knew and trusted in order to end her pregnancy. And it found that she had endured multiple human rights violations and instructed the Irish government to ensure that she was provided with effective remedies. And specifically, the committee detailed that these remedies must include compensation, the provision of rehabilitation and psychological support, and law reform, so as to ensure such violations did not reoccur, so as to ensure that in the future other women would not suffer the same human rights violations. And it gave the government 6 months to report to it on measures taken to give effect to these remedies. And the decision received significant attention in Ireland. It was widely disseminated and it captured the public interest. And I think in many respects it's true to say that it shocked the government and the political system in Ireland. And the text of the decision outlined in significant detail the facts of the case and what happened to Amanda Mellett. And although the decision is a legal document, in many ways it humanised the impact of Ireland's abortion law, and it concretised in very authoritative terms the harm that was being caused to women in Ireland who had to travel to other countries to access healthcare. However, we knew that on its own the decision was not going to be sufficient, and we knew that in order to shore up the influence of the case, to generate the kind of political and policy impact that we believed was necessary, we had to get some of the remedies within the 6-month time frame. And we knew that law reform was going to take time, and so we believed that it was critical to obtain the compensation and the costs of psychological rehabilitation within the deadline. Without it, we were concerned that the decision was going to become just another statement by an intangible Geneva-based body that sounds good but ultimately has no real political consequences and can eventually be ignored. However, we also knew that securing the compensation and the provision of psychological support was not going to be easy. The lack of familiarity with the committee procedure, the lack of precedent, meant there was no legal playbook. There was no series of established steps that we could follow in order to pursue remedies. And so in many ways, we were making it up as we went along. We were successful. In November 2016, the Minister for Health apologised to Amanda Mellett, and on behalf of the state, he offered her compensation and payment for the costs of rehabilitation. And this was the first time that the Irish state had provided remedies to a woman who had travelled for an abortion that would have been illegal in Ireland. And this was the first time it had provided remedies on foot of a Human Rights Committee decision. The government's pronouncement that it would provide these remedies confirmed in many ways the political impact of the decision. And in many respects, it was now clear that a constitutional referendum was inevitable, and it was just a question of when. In 2017, the committee issued its second decision in the Siobhan Whelan case, finding similar violations and again instructing the state to provide remedies. And the day after the Whelan decision was issued, the Irish Taoiseach announced that a constitutional referendum would be called in 2018. A special cross-party parliamentary committee was convened to make recommendations to Parliament and Government as to whether law reform was necessary and what form it should take. And at the end of 2017, it adopted its report in which it recommended comprehensive constitutional and legislative change, voting for Ireland's laws on abortion to be brought into line with those in other European countries, and citing the two Human Rights Committee decisions as one of three critical reasons why law reform was imperative. So what's the moral of this story? Well, that lawyers and legal mechanisms can play an important role in supporting social change, that thinking outside the box, being creative, using untried legal strategies, taking risks can pay off, that we are immensely grateful to those law firms and pro bono attorneys who made a contribution at different phases, to Arnold and Porter, who provided support at the early phase when we were developing the cases, and to Linklaters and Deckert that provided research and advice at later phases on comparative law and national regulations. Ultimately, I think it's true to say that we all have a role to play in important and momentous change. And law reform in Ireland was brought about by efforts of so many diverse actors over a long period of time. It was our immense privilege to stand with them and make a legal contribution to this long-time struggle for justice, for equality, and for women's health. Thank you.